Good morning, everyone, and welcome to, I think, what is Employment Rights Act Masterclass number 3. So if anyone can drop me a thumbs up in the chat just to let me know that you can hear me and see me all right. Perfect. So we're ready to get going. Just two things to start off with. Firstly, thank you so much for accommodating the time change this morning. I know we were originally scheduled for 11 and we had to move it at the last minute to 10 a.m. Wholly my fault, not my team's. For anyone who was on the last session will know that it's been a bit of a rough month. I ended up not being very well, being taken into hospital, and as an absolute surprise, the NHS have been very, very prompt with follow-up for some appointments for me, and I do need to dash off after the webinar to go and see the doctor. So thank you so much for accommodating the change at short notice, and also for probably the very high speed and slightly confused narrative in the last one when I'd only been out of hospital for a couple of days. Anyway, so this session we are looking at business protection, so harassment, whistleblowing and NDAs, so the changes that we are seeing under the Employment Rights Act in relation to these areas. So we're going to be talking about what's changing, how as small businesses we should be preparing, and also look at some practical guides as well. So I'm also aware that I owe the people from the last session, and then also it will be on this session as well, some freebies, so some policies from the last masterclass that we did. So those will be coming out this week as well for anybody who is waiting for those. So let's get started with the session. So why does this matter now? Why are we talking about it at this point? Well, as we hopefully are aware, the legal landscape has shifted significantly. So with sexual harassment, we have seen updates over the last couple of years. So we had the changes that came into force in October 2024 when employers had to take reasonable steps to prevent sexual harassment in the workplace. And we're now having further changes to that from the Employment Rights Act, where employers are going to have to take all reasonable steps to prevent sexual harassment. We also then have the changes to whistleblowing, so what's going to be included as a protected disclosure, and also the changes to what we can include in NDAs and settlement agreements. So it is very much changing the landscape over the course of this year and into next year. As we say on the screen, the stakes are real. Employment tribunal claims can cost thousands in legal fees alone before we even start looking at compensation. Reputational damage, particularly for a small business with a good reputation in a local area, and with as we know, the demon that can be social media, it can be really, really costly for businesses. So it's not just about legal compliance, it's about making sure that we're safeguarding our businesses and that we understand what our obligations are, so we don't accidentally fall over a tripwire, rather than, intentionally trying to break the law. Leadership accountability is increasing. So if you are in HR, if you're a director, if you're a senior manager, you are expected to be able to demonstrate that you can not only comply with the law, but you can help safeguard the business that you're working in as well. So there's a real responsibility around these areas. And it's hoped that these sessions are going to help you to shoulder that responsibility with a little bit less stress. So the legal landscape at a glance, as I've just said, we've got 3 interconnected areas that are sort of evolving together. So we've got sexual harassment, with duties at the moment saying that we have to, proactively take reasonable steps to prevent sexual harassment in the workplace. Once we get to the 26th of October of this year, so I don't know if it is the 26th, but it's October 2026, we are moving towards all reasonable steps that need to be taken. And we're going to expand a little bit on what that means through this session. And we've also got expanded obligations towards third-party harassment as well, because we are, as employers, going to be taking liability for third parties in our workplace. Protected disclosures, so whistleblowing protection under the Employment Rights Act from the 6th of April 2026, disclosures about sexual harassment will be explicitly recognised as qualifying disclosures, with enhanced anti-retaliation protections. So not only does this mean that someone who, for example, makes a complaint about sexual harassment could have whistleblowing protection, it would also mean that if they were dismissed under the 2-year threshold, or from 2027 under the 6-month threshold, they could potentially have the right to bring an automatic unfair dismissal claim, because hopefully we all know that if we are dismissed for making a protected disclosure or blowing the whistle, that is one of the grounds that we can claim automatic unfair dismissal. So it's a little bit like adding an extra ground into automatic unfair dismissal by the back door by bringing it in as a protected disclosure. NDAs and confidentiality agreements. So settlement agreements and confidentiality clauses face new restrictions. So there will be provisions that prevent workers from speaking. If there are provisions that prevent workers from speaking out about harassment or discrimination, they will be void. We won't be able to include these claims within settlement agreements. We are going to have to just deal with these issues within the workplace and potentially take some hard decisions around consequences when we do find sexual harassment, rather than just settling with victims. So what the law expects today. So sexual harassment, as we hopefully all know, this is unwanted conduct of a sexual nature that violates someone's dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. It includes verbal comments, physical behavior, jokes, images, or gestures. Hopefully we also all know that this definition is deliberately broad and it's judged from the perspective of the recipient, not the intent of the perpetrator. So if we have somebody who in defense says, well, yes, I accept I did behave in this way, but it was not my intention to offend. I thought this person would take it as a compliment. That is not a valid defense. Remember, in this definition, it's around the purpose or the effect of that behavior. So if the effect of that behavior on the recipient has been that it has been unwanted and they found it offensive in line with the definitions within the Act, then it is classed as sexual harassment. Vicarious liability. So employers are legally responsible for harassment by employees on other employees where it's done in the course of employment. Again, this is very, very broad. So work, social events, client entertainment, business travel, even work-related WhatsApp groups can create this liability. The location or timing, the fact that something's after hours doesn't automatically exclude employer responsibility if there's a work connection. We did have a case late last year where someone was giving somebody else a lift to work, and that was found to be within the course of employment, even though it was a voluntary arrangement entered into between the employees. It wasn't under a carpooling scheme or policy or anything like that, but that was found to be within the course of employment. So very, very broad. We're responsible for employees even when we can't directly keep an eye on them. So the reasonable steps defense. Now, whilst we may see lots of marketing, including our own, around this on LinkedIn, the reasonable steps defense is difficult. So employers can defend vicarious liability claims by proving that we've taken all reasonable steps to prevent harassment. The evidence really, really matters here. So we need to be showing that we've got clear and accessible anti-harassment policies, not just that we have the policies, that we've circulated them, that we've made sure that people have read them, that we've made sure people have understood them, that we've got regular and meaningful training that's not tick box, and ideally training that also reflects our policies so that we can check that people have actually understood what the rules are, that we've got visible and open reporting channels, that we don't hide how that you report sexual harassment, that we don't make it very, very difficult. So if someone fills in the wrong form or follows the wrong web link and they haven't written it in the right potential format, that we're not shutting these things down, that we're very much encouraging, however that you want to report these things to us, even if it's outside the set channels, we will receive that and we will investigate it. That we have swift, impartial investigation and action, that we have documented risk assessments. And this isn't just a documented risk assessment that was done back in 2024 when we first thought we had to do these. We should be updating risk assessments regularly. So thinking about, has our workforce changed? Who's come? Who's gone? What are the working practices? Actually, have we become more aware of something or certain types of behavior that mean that we need to update these risk assessments? Have we implemented training? So do we have policies? What do the policies say? Does the risk assessment contradict or does it support the policy? So we need to really, that should be reviewed quarterly to make sure that that is up to date. Manager accountability and capability as well. So making sure that managers understand what sexual harassment is, what they should do if somebody reports it, and what preventative action we should be taking. So specific training for managers is also something that you could be looking at. So reasonable steps must be proportionate to your business size and sector, but where too small is not a defense, as the bar is very, very much rising. And there's a huge number of resources out there that are available to small businesses and that are very cost effective. And when we think about what a sexual harassment claim can cost a business, the cost of training your staff, getting bespoke policies, dealing with risk assessments is minute in comparison to what this could cost your business. Because a judge isn't necessarily going to say, oh, well, yes, you're far too small for me to give you this award against you in relation to compensation. And certainly your lawyer is not going to say to you, oh, you're far too small for me to charge you fees. So you need to be thinking that this should not be something that's reactive. This needs to be a core part of your business when we're thinking about how we control risk. How do we make sure that we are still operating in a year, 18 months, 24 months? What are the critical things that could mean that we end up shutting our doors because it has cost us too much money to defend something, or we've had a whopping compensation claim against us? So this should not be reactive. This should be considered to be one of the top tier things that we should be thinking about through the course of this year. And it should, like I say, be woven into the fabric of our business, because if we don't, we have got absolutely no shot at the reasonable steps defense. It is incredibly difficult to run, and you have to be able to evidence it very, very clearly. So we've got a bit of a poll running. So for anyone who hasn't spotted that, it should be, I think, on the right-hand side of your screen. So how confident are you that your business currently meets what will become the new sexual harassment prevention duty? So taking all reasonable steps. So think about that. All reasonable steps, every step you could ever possibly take, bearing in mind we don't actually have the regulations yet that tell us what all reasonable steps are. So for anyone who's saying that they are very confident, we've reviewed and updated everything, you have more confidence than me, because we still don't know what the government is going to say that all reasonable steps are. Somewhat confident, so we've done bits but not a full review. Not confidence, new territory for us. Yeah, I understand that. It's new territory for lots of businesses. I didn't realize there was a new legal duty. So good that we've got none in there. Nice to see the numbers dropped a little bit in that very confident. But yeah, you know what, fair play that there's three of you who still think, yeah, we've reviewed everything, we can take all reasonable steps without currently knowing what they are. So the preventative duty that is already live. So as I've just touched on, we need to take reasonable steps at the moment. That all reasonable steps doesn't come into force until later this year. So the risk assessment approach, so identifying hotspot scenarios in your business where you've got client-facing roles, work events, especially those involving alcohol, where we've got business travel, power imbalances, junior staff mixing with senior managers or clients, isolated working, customer interactions, people who are locking up on their own, and places where perhaps either you have CCTV, you don't have CCTV. You know, do we have somebody where there's been complaints in the past, or someone who we think actually might be a little bit high risk? Who is that person working with, and what is their exposure? What training have they had? So document your assessment. What could go wrong? What's already in place, and what gaps exist? If you don't know where to start with this, we do have a template. So if you would like the risk assessment template, drop it into the chat and we can get that circulated as well. So what reasonable steps look like at the moment? So tribunals and regulators assess prevention evidence. So for SMEs, this can include updated policies, communications to staff, scenario-based training, so not just policy reading, visible reporting routes, manager capabilities, so all the things that we've just touched on. Something I really like to see as well when I go into businesses, so I do on-site visits with clients when I'm working with them, is actually seeing the documentation around the premises. So if you spot something that could be sexual harassment, this is what it could look like. This is how you report it. We're here to support you. So having posters and graphics up around the business that show that you take this seriously. And that's also going to be really key when we've got the third party liability that comes in later this year. So having those statements when someone comes into your business, we do not accept this kind of behavior. And this is the approach that we take, and we do take these matters seriously. So documentation is key, making sure that we are logging everything that we're doing. So keeping training logs so we can see who's done the training, who's passed the training, how long perhaps it took them to do it. Did it take them 14 attempts to pass their sexual harassment training? Maybe this is someone who needs to sit down with HR and have a little bit of one-to-one coaching. Or perhaps we need to get them to read the policy again, or think maybe is there a better environment that we can train them in if something like e-learning isn't perhaps working for someone who's taken so many attempts. Making sure we're doing our risk reviews and also having action plans in place, because even though the duty doesn't come until October 2026, so several months away, we're liable from that point. So we need to have this stuff embedded in the workplace and ready to go by then. Proportionality. So reasonable steps are proportionate to business size. A 5-person firm isn't expected to operate like a multinational, but doing nothing or relying solely on buried policies or thinking we're too small will actually make your risk probably higher than that of a multinational. So focus on clarity, accessibility, genuine capability to respond. Quality matters more than volume, but the absolute minimum really does need to be to make sure that we are educating staff on what sexual harassment means, what is okay and what is not okay, where the line is and what the legal definitions are, and that comes down to training. So we've talked about the higher standard already, so we are going to have to now take all reasonable steps. This wording is a significant shift from just taking reasonable steps to now taking all reasonable steps that you can possibly take. So we are expecting a much, much higher bar here, not those minimal efforts. We are going to get the wording, hopefully through regulations, that will tell us what can be included in all reasonable steps. But what we're anticipating is the stuff that we have already touched on. So as a minimum, making sure we have a policy, we've done training, we've done the risk assessment. So I'm repeating myself here, but this is because no matter how many businesses I go and see and how many I work with, there are always gaps around this sort of thing. So have a look at your blind spots and think, are we doing everything that we possibly can to prevent sexual harassment in the workplace? We've got third-party harassment liability. So employers will again be liable for harassment, not only of workers, but also by third parties. So customers, clients, suppliers, contractors, anybody coming onto your business premises who is not an employee, or not even onto your business premises. If you've got someone who is engaging with members of the public on Teams, for example, we are going to have to take all reasonable steps to prevent sexual harassment in the workplace, whether it is from our employees or whether it is from third parties. So making sure when we are engaging with suppliers, our contracts and the documentation that we're sending out should contain a commitment or some sort of statement that we expect people to sign to say, we understand you have strict policies around sexual harassment. We understand what behavior is and isn't acceptable, and we are committed to the highest standards of behavior when it comes to working with your staff. So it's front and center. This is something that's important to our business. This will not be tolerated. And ultimately, if you commit sexual harassment in relation to a member of our staff, that we're going to be classing it potentially as a breach of contract action. So again, reviewing the contracts that we have with our suppliers to make sure that we have that ability to be able to terminate arrangements and take strong action if sexual harassment is found to have occurred. So prevention by design, so building prevention into your systems from the start. So onboarding, contracts, events, client engagement, make sure that this is routine and that it isn't reactive. So I'm just going to have a quick look at the questions before I move on to the next section. So we have a risk assessment and train staff. How often should we retrain? So as a minimum, I would be saying annually to train your staff. So we do GDPR. Most people do GDPR data protection every year. Sexual harassment really should be an annual thing. Even though we all think it should be common sense what sexual harassment is, whenever I go out and deliver this stuff in person and I ask someone, can you tell me what the definition of sexual harassment is? I always get the traditional stuff like, don't touch people who don't want to be touched. Well, that's great, but actually the definition is really, really wide. It's quite a legalistic definition, and it's really, really important, one, that we're reinforcing where those boundaries are and the real key points around the fact that, you know, we've got purpose or effect. So it's the effect of behavior. It's not just the intention of the perpetrator. That we're thinking about things like banter, the risks of personal liability, third parties, you know, the fact that the law is evolving, one, not only through case law, so we have specific things we can work through and give fresh examples every year, but also to make sure people are absolutely current. Because I think if there were an issue and you've got someone who has committed sexual harassment and they haven't done any training for a couple of years, skill fade is quite quick. So how quickly we lose new skills if we're not constantly reinforcing them. So my view on that would be annually. So a quick poll down there. So if someone reported sexual harassment in your business today, what would actually happen next? We have a clear documented process and we train managers. HR would handle it, but the process isn't very formal. It would depend on who they report it to, or finally, honestly, we're not very sure. So clear documented process and trained managers, that's really good. HR would handle it, process isn't very formal. Nothing necessarily wrong with that. You might be a small business, as long as that reporting channel is clear and we are handling and dealing with these things, that's also fine. It would depend on who they reported it to. That's a little more high risk. I mean, we should be relatively consistent with what would happen next. Thankfully, no one is saying that they're honestly not sure. So we're now going to move on to protected disclosures and whistleblowing. So quick refresher on protected disclosures. So workers, not just employees, so including agency workers, contractors, and some self-employed individuals in certain contexts, are protected from detriment or dismissal if they make a protected disclosure. Protected disclosures cover key themes. So if someone brings to your attention issues around criminal offences, breach of legal obligations, miscarriage of justice, health and safety dangers, environmental damage, or deliberate concealment of any of the above, it could potentially be classed as a protected disclosure. If that disclosure is made in good faith, which is very broadly interpreted, I'd almost kind of remove that from the definition, and that it's a matter of public interest, then it's likely that it's going to be a protected disclosure. Now, the reason why I never talk about the good faith stuff and the reasonable belief is because it is so very, very difficult. There have been cases even where a judge has been mostly convinced that someone has done something either to protect their own position, but has made a disclosure that is in the public interest, that it's still classed as a protected disclosure. So I would never lead from the point around good faith or reasonable belief. I would always be focusing on if something's in the public interest or if it fits in one of those categories. So what we are getting is that reports around sexual harassment are going to now be included within these categories. So good practice for employers: establish safe and accessible reporting routes, offer multiple channels, so line manager, HR, confidential hotline, or external if appropriate, ways for people to make disclosures. Remember, whistleblowing is distinct from a grievance. Whistleblowing or protected disclosures are more high risk for your business because they're about public interest, not personal complaints. So personal complaints are typically grievances. There can be instances where the two can overlap. So where someone raises a personal grievance, but actually it's about a much broader issue that does have a public interest, that could potentially be a protected disclosure. So what's really, really important is that when we are triaging complaints, that just because someone is complaining about something that's personal to them, that we don't rule out something being a protected disclosure. It's not necessarily down to the employee to identify their complaint as a protected disclosure. So if you read something and you think this fits that category that Alyssa was wittering on about on Tuesday, the 10th of February, well, you should be informing the employee, we are going to be investigating this, but actually what we think you have done is raised a protected disclosure. So we are going to be investigating it as such. You will get your grievance outcome. We will investigate the grievance, but actually this now has additional protection and this is going to be taken very seriously. That person then has protection against retaliation. So that includes obvious acts, so dismissal, demotion, and any substantial detriments. So if someone's excluded from meetings, if they're iced out by colleagues, if they're given poor performance ratings or project removal, or they're managed out, retaliation claims are taken very, very seriously by tribunals, and they're very good at seeing through certain types of behavior when it comes to detriments as a result of protected disclosures. So a grievance typically is a personal complaint about treatment. A protected disclosure raises matters that are in the public interest, even if it also affects the worker personally. Sometimes a complaint can be both, and we should be assessing each case carefully and applying the appropriate processes. Okay, so what's going to be changing? As I've just said, from the 6th of April 2026, we are going to be explicitly including sexual harassment as a matter that can form the basis of a protected disclosure. So this change closes the gap and it strengthens protection for workers who speak up. It's a little small on screen, so this is going to be circulated afterwards. You will be able to have the deck afterwards, and hopefully this will give you some nice notes and a bit of extra detail should you need it. So when someone reports sexual harassment, whether it's their own experience or something they've witnessed, we've now got to treat that with the same procedural rigor as other whistleblowing matters. So we treat it confidentially within operational limits, we promptly acknowledge it, and we handle it impartially. Ensure we keep clear documentation and evidence preservation, that the individual has protection from any form of retaliation, and it's escalated to senior leadership where appropriate. Retaliation always doesn't always look like dismissal, so watch out for any sort of it's like hard to notice stuff, but where attitudes are changing or you think someone's being treated poorly, we need to jump on that. So keep an eye on that employee, make sure they're looked after, and make sure that we are keeping an eye on people who are working around them, near them, reporting into them, or who they are reporting into, to make sure that those relationships are preserved and we're not seeing people inadvertently targeting someone or cooling off their relationship towards them. So managers should be trained to recognize this and avoid those risks. And a worker who makes a sexual harassment disclosure, who is then subjected to a detriment, even if it's unintentional, has a very strong legal claim. So we'll have a look at handling in practice. So a junior team member who reports that a senior colleague has made repeated inappropriate comments during a client event. The report is made to HR, who must now acknowledge and document it, assess whether it's protected disclosure, likely yes from April, ensure confidentiality where possible, investigate impartially, monitor for any sign of retaliation, provide support and clear communication to the discloser. So we do take all reports seriously. We preserve evidence, act swiftly, and communicate processes and timelines. We don't dismiss it as banter. Banter is not a thing. It's not a thing. For anybody who's sat my sexual harassment courses, you will know how I feel about banter. Nobody ever makes a really good joke that makes everybody laugh and then says, oh, it's only banter. It's always used to cover up poor behavior. We don't delay. We involve conflicted parties. We don't, sorry, involve conflicted parties or allow disclosures to be sidelined. So we've had a quick question there. So how quickly should we be training new joiners? Is it acceptable for them to join the next annual training? I assume it needs to be done during induction. My preference is during induction, because at least then we have taken reasonable steps to prevent it when somebody has walked into the workplace. So again, not to kind of, because it's not the way that we kind of run these sessions in terms of pushing our own products, but the RE learning packages, people have access to them for 12 months. So actually you can stick someone on the sexual harassment course on day one. It's really, really fluid and really, really flexible, how you can train people up when they're new starters. So you don't need to wait for annual training when somebody comes in. So although it's UK legislation, we made the assumption we should train all employees regardless of location. Yes, that's correct, because particularly where you've got UK employees who are working with people in other jurisdictions, it means everybody's working from the same foundation of behaviour, and also means that you're likely to lower your risk in other jurisdictions as well. Okay, so if somebody discloses but states they do not want anything doing about it, I assume we still have an obligation to, even if it's against their wishes. Yes, we don't need victim consent to do an investigation, because remember, our obligation is going to be to take all reasonable steps to prevent. So if we're aware of an incident and we don't do anything about it just because somebody said they didn't want it pursuing, we still potentially have a very high risk individual walking around in our business. So we can still investigate, and we can still take action, even if somebody doesn't want anything to happen with that disclosure. So Megan, when you mentioned before about third-party harassment prevention, how would you use contractual arrangements with third parties, so suppliers, contractors, to assist prevention steps? I'd be making it a key contractual term that they either have anti-sexual harassment policies, that we expect them to have either educated themselves, or even go as far as to say that we expect training to have been done, and also note that it would be a key term of our contracts that we expect a certain standard of behaviour, and a breach of that would be a material breach. Some really good questions today. Thank you, everybody. So NDAs and confidentiality. So we're coming on to the last section now. So non-disclosure agreements, NDAs, confidentiality clauses are common in UK employment contexts. We see them in settlement agreements as a way of resolving disputes. We use them sometimes in employment contracts to protect trade secrets, and in handbooks around general confidentiality. So we have got legitimate purposes. We are not removing the ability to enter into confidentiality agreements or have NDAs. There are currently legal limits around how these can be used. So we can't block statutory reporting to regulators or the police. We can't prevent people from asserting legal rights. And we can't have overly broad warning or punitive clauses in there. And there's a practical risk with NDAs as well. So particularly around very aggressive approaches to settlement agreements. If people feel intimidated into silence around harassment or discrimination, it's not necessarily a good look. So the Employment Rights Act has included provisions that make certain confidentiality clauses void and unenforceable. So we won't be able to include in there anymore that people can't disclose that they've experienced harassment or discrimination, we won't be able to prevent them from describing the employer's response or lack of thereof to that conduct. We won't be able to stop people obviously making protected disclosures about this to external agencies, or reports to regulators, police, or appropriate authorities. So we need to update our templates, so our settlement agreements, our NDAs, we need to have a look at those and make sure that there's nothing in there that means that we're going to fall foul of this. What does remain legitimate is confidentiality protections for genuine business interests, so trade secrets and intellectual property, client or customer lists and relationships, pricing, margins, commercial strategies, confidential business plans and product development, reasonable restrictions during settlement, so settlement amounts, and the key here is precision. Wording's got to be clear, specific, and necessary. So this doesn't mean that we can't settle other legal claims. It doesn't mean that we can't, for example, do a settlement agreement around something like unfair dismissal or bullying. It's that we are going to be restricted now around settling or excluding around sexual harassment. So in the poll, what area feels like the biggest risk for your business right now? Preventing sexual harassment, handling whistleblowing, NDAs, or all of the above? Sexual harassment coming out top, I'm not surprised. You know, that is the one that really is that taking those all reasonable steps. There really is going to have to be a culture shift here to making this the fabric of our business and seeing this as a key business risk rather than, oh, well, we'll call the lawyers when it happens, because that's just not going to be good enough anymore. So what should we be doing now? So foundations, review and update your policies, confirm reporting channels are clear and accessible, issue interim guidance to managers on first response expectations, start documenting your prevention steps. 60 days, over the next 60 days, so deliver or refresh scenario-based training for managers or staff. So maybe have a look at the market, see what's available out there. If you are just doing annual training where you're relying on the availability of one person to come into your business every year, maybe look at something that's a bit more fluid or a bit more flexible. Conduct your formal risk assessment, implement third-party controls. So have a look at the contractual clauses that you've got, and also test your reporting routes. So can staff actually find and use them? So maybe do a bit of a mystery shopper exercise and see how your managers or senior leadership handle this. And then as we head towards 90 days, so review and redraft NDA and settlement agreements, formalize your whistleblowing workflow and any anti-retaliation controls, audit your record keeping, so your training logs, policy acknowledgement, investigation files, and make sure you're scheduling periodic reviews of all of the above. So readiness check, this will come out with the deck. So a nice little bit of a checklist here for you to work through. Closing tips and takeaway, again, this will be available for you in the deck. I'm just conscious that we are running a bit over time. If this has got you thinking and you're thinking, right, we need to look at our systems, we need to look at what we're doing, we need to look at how we're training, don't forget about us when you're doing your research. So we do offer e-learning on 12-month subscriptions where you get access to all of our e-learning catalogue on demand. You can track who's done what, how many attempts they've had, who's passed, what their score was. You get their certificates, you get the training logs. All that audit piece is done within our e-learning software. It also nicely links into our HR software where people can report and raise grievances, and it's handled within our system and documented well. So you've got that nice consistency and also the open reporting channels. And then for people who feel completely overwhelmed and need extra help, there's always me and my wonderful advice team. We are always here to help you as well. We offer a great package of everything all linked together. So that's my plug for today. So for anyone who doesn't actually want to pay to use us, there's always the podcast. There's always these webcasts that I think we're kind of doing every other week at the moment, and all of the material that we put out on LinkedIn as well to help you for free. So I hope that we have got to all of the questions. If there is anything that you want to raise with me, I'm always happy for you to contact me after the sessions. And as always, if you wouldn't mind dropping us a review on Trustpilot, that would be absolutely fantastic. Thank you so much for attending. I'm sorry that we've run over by 3 or 4 minutes this week, but hopefully it has been useful to you all. The slides will be out either today, I know Dawn's really prompt with these, or in the next couple of days, and we'll also get that risk assessment template circulated as well. So thank you so much. That's gives you all the rest of your mornings back. And again, apologies for the disruption with us having to move it from 11 o'clock to 10 o'clock. So thank you all for your flexibility on that one. We have got another session, I think, in 2 weeks where we're going to be touching on, I think it's trade unions, agencies, so the final nitty gritty bits of the Employment Rights Act, which will conclude the 4-part masterclass. And then all of that will be available on demand with the templates. And we're also going to be expanding on these sessions within our e-learning software as well. So half an hour is very, very quick. Each session will be expanded to an hour and a bit more in depth. So if that's something that you're interested in to expand your own knowledge, then that will also be available. Thank you very much. That concludes this session, and I hope you all have a good rest of your day.